Hey, how y'all doing? It's Chris with Bama Law. I thought we'd go over the most recent Supreme Court cucking that they have done. Yet again, they have cucked out. Uh, we have a TRO that was done by the AIDS Foundation for it's under the USA, not AIDS, as in AIDS. AIDS is in the disease. It was an AIDS Vaccine Advocacy Coalition et al. And others. Um, on application to vacate the order issued by the U.S. District Court for the District of Columbia. And this is all about USA ID money. They want $2 billion to pay out. They claim for things that they've already done. I don't know. Nobody knows what they've done. We don't even know if they've done it. We have no clue. So let's go through it's not a very long opinion. This should be under 30 minutes, so let's try to get it done. On February 13th, U.S. District Court for District of Columbia, this is the actual majority. It's a 5-4 decision. It's freaking unbelievable. But here it goes, because it's going to come back to them. They're just punting it, as usual. You know, the Chief Justice, again, is a pussy, and he cucked it. And that useless idiot, Amy Coney Barrett. Oh, I went to Notre Dame for law school. Oh, I'm so smart. No, you're a moron, because she's one of the ones that voted it cuck and send it right back, and deny the executive branch's authority to not make the payment because they think it's fraud. They have the authority, so they want. Oh well, you could pay it out, and once you pay it out, we could still litigate it. Like you're going to get the $2 billion back, which the other justices go through with this and discuss it. On February 13th, U.S. District Court for the District of Columbia entered a temporary restraining order, enjoining the government from enforcing directives pausing disbursements of foreign development assistance funds. Present application does not challenge the government's obligation to follow that order. Okay. Well, on February 25th, the District Court ordered that the government issue the payments. Government had to issue the payments for a portion of the paused disbursements, those owed for work already completed. And that's a big deal because whether I like what they've done or not, if the person did the work, whether it's stupid or not, it could have been, I don't know, $2 billion to fill in potholes in the road in front of the White House. Dumb idea, stupid payment, bad job or bad contract, but they made it. So in the light of we don't want to screw up with contracts. We don't want to screw with that. In light of that's I understand that reasoning. And then it goes on, before the issuance of the district court's temporary restraining order by 11:59 on February 26th. That had to be done. Several hours before that deadline, the government filed this application to vacate the district court's order and requested an immediate administrative stay. That's just temporary. That's all it is, so they can litigate it and hold the money. The Chief Justice entered an administrative stay shortly before that deadline and subsequently referred the application to the court per curiam. Excuse me, I almost said per curiam, to the court. The application is denied. They have denied it, 5-4. Given that the deadline and the challenge order has now passed, and in light of ongoing preliminary injunction proceedings, there is preliminary injunction. None of this makes sense because the money, nobody can make the chief executive pay it. Like what are they going to do? Send a U.S. Marshal down to the Treasury Department and say, hey, they said to pay this bill, write a check. I mean, that's it. Okay. What are you going to do? Send U.S. Marshal to arrest the president? Well, he's kind of got authority over them, too. They're causing their idiocy is causing a constitutional crisis. And it's going to happen. We're going to see a fight between Article 2 and Article 3. Who's got authority? The application was denied. Given the deadline challenge is now passed in light of the ongoing preliminary injunction proceedings, the district court should clarify. This is what they want them to do. The Supreme Court wants the district court to clarify what obligations the government must fulfill to ensure compliance with temporary restraining order with due regard for the feasibility of any compliance timelines. And then the entered order by the Chief Justice is vacated. Now, what gets interesting is the dissent. This isn't that many pages. It looks like it, but it's not, and we're not going to go through that many. This is Alito, our holy justice. Thank you very much, and Justice Thomas, our other patron holy saint of the Supreme Court. Justice Gorsuch and Justice Kavanaugh joined dissenting from the denial of the application to vacate order. Now look, guys, they only missed one. They just needed one. Stupid Barrett. I don't know what the hell Trump. These presidents think they have to always appoint something. Oh, Yale or Harvard or no. How about just a regular freaking lawyer? How about we just do that? How about we just have a regular trial lawyer or someone who's done 15 years? Somebody who's not 60 years old, just who hasn't had to clerk with the Supreme Court or do something else, uh, you know, licking or sniffing the taint of a damn justice in order to get their way through their career. Does their question is they're raising is, does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be no. It should be, how about no? No. It should be no. Emphatic no. But a majority of this court apparently thinks otherwise. I am stunned. Alito is writing this. All right, Alito's writing this. Go back to yellow. Now. Yeah, right. That's good. I agree, Sean. Yep, that would be great. Just a regular one. And here I am jumping on this way late. I know everybody else has done this. But let me go on. Let's read the shittiness well, we've read the shittiness. Let's try to salvage something here. In capsule form, this is what happened. Respondents are a group of American businesses and scam artists, I mean nonprofits, that receive foreign assistance funds from the State Department and USAID. That's it, the scam artists. They brought suit and claimed that the current administration, where's my draw? I don't have my highlighter. Current administration's temporary pause of foreign assistance payments is unlawful. So the district court issued what's called a TRO. It's just the whole thing's in place. Everybody just chill out, requiring the government to halt its funding pause. It based that decision on a finding that the respondents are likely to succeed in showing that the government violated the APA, which has been discussed in other gun-related cases of recent. After issuing the TRO, the district judge grew frustrated with the pace at which the funds are being dispersed because they want to get their buddies paid out. And on February 25th, he issued a second order requiring the government pay out approximately $2 billion. This is starting to become. This is going to create literally another. I think it's 1831 when Jackson had his famous quote. I think it's Worcester v. Georgia with the Indian Removal Act, where he essentially says, or I think the quote is, "Well, Mr. Chief Justice Marshall, you have your order. Now enforce it." What are they gonna do? Tell me if anybody can tell me what the Supreme Court's going to do or could do. I'm all ears because it's not going to happen. They're not going to do squat. The judge brushed aside the government's argument that sovereign immunity barred the enforcement order, and he took two steps that, unless corrected, would prevent any higher court from reviewing possibly stopping the payments. He labeled them as a non-appealable TRO, and second, he demanded the money be paid within 36 hours. If I were Trump, I'd say, suffer. No, I'm not doing it. Kiss it. I'd say, here, you got your order. Here, it's Here's your order. Yeah, yeah. I'm not doing it. What are they going to do? Nothing. There is nothing they could do except for going, get mad at him and go pout like little babies that they are. Those 5 little whiny little twits that voted for this. The left, this left the government little time to try to obtain any review, regardless of what it regarded as a lawless order. The government moved for a stay pending appeal in district court. The judge shrugged. I mean, this is pretty harsh language out of a Supreme Court. I think they're getting sick of it. I think they're tired of this shit. I know I am, and I know other lawyers are tired of it. But the judge shrugged off the government's sovereign immunity argument and ignored the government's representation that most of the money in question, and yes, Sean, now I'm going back to the top 25 law school thing. They're obsessed with that. I should have went to UA, which University of Alabama, which kind of been a top 15 school for a long time, and I just didn't want to pay the money. That's flat out. I paid like $36,000 for my law school education, so oh well. I passed the same damn bar as everybody else, or at least in my state. So the government quickly filed. Excuse me. The government quickly filed an appeal in the United States Court of Appeals for District of Columbia, but with only 4 hours to spare before the payment deadline, the D.C. court dismissed the government's appeal because it took the district court's TRO label at face value and determined it lacked appellate jurisdiction because TROs have to be approved. With nowhere else to turn and the deadline fast approaching, the government asked this court to intervene. At the last moment, His Holiness the Chief Justice issued an administrative stay. Unfortunately, a majority has now undone it. As a result, the government must pay $2 billion post haste right now, not because the law requires it, and the case isn't done, but they're wanting the payment. So they want them to pay it, litigate the damn case, figure out that it was fraud or whatever, and then go, okay, well, now you got to pay it back. Those people will be so long gone, it's not even funny. They will be long, long gone. As the nation's highest court, we have a duty, and this is Alito writing, to ensure that the power entrusted to federal judges by the Constitution is not abused. Today, the court fails to carry out that responsibility. Man, that is not common. You might have a judge or a justice do a little jab here and there at another, or at the court, or at the majority. But for them to say just straight out, just flat out, that today the court fails to carry out a responsibility, wow. I mean, that's pretty big. 2, time does not allow a lengthy discussion of the legal issues. No, it needs to be done. Denied, and send it back and let them deny the payment. But a brief summary suffices to show the district court's order should be vacated or at the very least stayed. How hard would that be? Let's just stay it. Let's figure it out. Nobody needs to get paid. We'll just take the case, fight it out in the courts, and you might get paid in 2-3 years. But you'll get paid if you win. No, they want to pay now. Right now. It's like Cartman wanting his freaking KFC. No, I want my KFC now. To start, it is clear the district court's enforcement order should be construed as an appealable preliminary injunction, not a mere TRO. Now this is important because they're explaining the differences here. A TRO, as its name suggests, is temporary, and its proper role is to restrain challenged conduct for a short time while the court considers whether a more lasting relief is warranted. The order here, which commanded the payment of a vast sum of money that in all likelihood will never be fully recovered, is not temporary. Nor did the order merely restrain the government's challenged action in order to preserve the status quo. It acts as a mandatory injunctive relief, requiring affirmative action by the government, and given its likely irreversibility, any moron on the street you ask is going to say, well, that damn money's gone. It is gone. It's already been spent anyway, but it's definitely gone. It's out. It's like an Audi 5000. The district court's enforcement order effectively gave respondents a portion of the ultimate relief they seek. For these reasons, the Court of Appeals had jurisdiction to consider the government's appeal. And remember, Court of Appeals kicked it back, and they said, and so they took it to the Supreme Court. That's all they wanted to do. The government's appeal, and we have jurisdiction to review and summarily vacate that court's erroneous judgment. But they didn't want to. Why? They cucked it again. They're cowards. I don't know. Those two justices, I don't get it. Every time we have a State of the Union, the Chief Justice is there. At least he's not like Rehnquist, where he has these stupid gold stripes, like he's a admiral or something on his robe. That was the most audacious, pompous outfit I have ever seen. So at least he doesn't have that. But he's always there every time. He's got to make himself known. And he was just smiling last night to Trump. Oh, yeah, nice to see you. Never mind that he's going to freaking fist him right up under there. Fisting him right under the robe. And considering whether to issue a stay, we ask at a minimum a few issues they're going to look at. 1, whether the moving party is likely to prevail on the merits, and 2, whether that the moving party is likely to suffer an irreparable harm. I'm tired, so forgive me. My reading's not good, and I don't have any reading glasses. In close cases, we also take into account other equitable considerations. Remember, the U.S. courts have two. They have two under common law. They have two prongs. Okay, you have equitable relief and you have legal relief. In this case, they're wanting an equitable relief. Equitable relief is just that. It's to do something that is right. It may not be a legal mechanism by it, but they're at least wanting an injunction to say, hey, stop, just wait a second. Let's get our ducks in a row. So that's what they're doing here. A lot of states used to have, Tennessee still has it, where it's called a split system. Chancery court, that's your equitable relief court. You had a law court. Hence the term, I don't know why no one says it. Well, I don't know why no one says it now. I guess maybe 100 years ago, there used to be attorneys at equity, but there was always attorneys at law. There was two different systems. He goes on to say, the likelihood of success, that's one of the standards. The government has shown a likelihood of success on the merits of its argument that sovereign immunity deprived the court of jurisdiction to enter its enforcement order. The president should have some sovereign immunity to act as the chief executive. The courts do not. This started with Marbury v. Madison. This is a problem dating over 200 years ago because John Marshall had to whip his dick out and show how big it was and sling it around in a case that had nothing to do with it. This is where we're at. The Article 3 courts always want to be top dog. And until someone else does something, then somebody, whether it's like on Sean's stream earlier, talked about getting rid of the Judiciary Act. We could. They could do it tonight. They could do it tonight if they wanted. President sign it, boom, they're all gone. And then they could reconstitute a new one and fill it all up with new people. They could do that. They could get rid of all the district courts and just make them, 2 district courts per state if they wanted, with one circuit. They could do anything. Are they going to do it? I doubt it. But until someone starts, slamming somebody's gym dog in the door, nothing's going to end. Sovereign immunity bars a suit by private parties seeking to impose a liability which must be paid from public funds in the Treasury. But that is exactly what the district court ordered. Now, sovereign immunity may be waived, but to sustain a claim that the government is liable for awards of monetary damages, the waiver of immunity must extend unambiguously to such monetary claims. Lane v. Pena. It's from 1996. Attempting to satisfy this strict requirement, respondents point to the APA. Again, we're going to go over that another one because there's an ATF case that deals with that. That was a big deal recently. I think it was the end of last year. And the braces, issue with braces, which luckily Luckily, Cash is now the head of the ATF, and they're on the border doing their what they need to be doing, rather than going after people for, I don't know, my barrel's an inch too short. That's not worth 10 years in prison. We've got to do something. We got to change it. And just having him as the head is not going to do it. It gives us 4 years. That's it. Attempt to satisfy the strict requirement. This strict requirement, respondents point to the APA's waiver of sovereign immunity for certain actions seeking relief other than money damages. That language, as we have explained, distinguishes between specific relief, which is permitted under the APA, and compensatory or substitute relief, which is not. But the relief here more closely resembles a compensatory money judgment rather than an order for specific relief that may have been available in equity. An injunction to compel the payment of money past due under a contract, and this is where equitable relief comes in, especially in contract law. And an injunction to compel the payment of money past due under a contract or specific performance of a past due monetary obligation was not typically available in equity. You sue in law. But this is what they're getting at. There has to be some way to fix it. And if there's not a legal mechanism, you hope for one in equity. Sovereign immunity thus appears to bar that sort of compensatory relief. Okay. That the district court ordered here. Now, I'm reading this for the first time, other than others going through it. Hoping to escape the conclusion, respondents point to Bowen v. Massachusetts. In that case, we held that the APA's waiver of sovereign immunity, which is an act, again, it's an act conveying rights to the branches of government. I'm pretty sure it only covers the executive. It's the only time I've ever seen it. There'd be no reason for it to cover Article 1, and definitely not Article 3. District Court's judgment reversing a final order of the Secretary of Health and Human Services refusing to reimburse Massachusetts for Medicaid expenditures. Unlike the District Court's order here, that judgment did not purport to order that any payment be made by the United States. Excuse me. Rather, Bowen simply recognized a basic reality of APA review. After a court sets aside an agency action, a natural consequence may be the release of funds to the plaintiff down the road. Again, they're saying, look, hey, we can put a pause on this, and you can pay. They may still get paid. We might figure out this is all fine and good. But no, they don't even want to deal with that. The majority wants them to just pay it out and then deal with it. Indeed, we have since clarified that Bowen has no bearing on the unavailability of an injunction to enforce a contractual obligation. An injunction is a legal relief you file. You wouldn't. You might go to have if you file a breach of contract, you might seek to. I don't know. It's probably a better description. You would argue something like estoppel, but if the court doesn't have the authority to enjoin something under law, it just doesn't. And usually you're dealing with contract issues. It's already done. Money that you were owed may have already been spent to someone else in breach of that contract. You may be suing for quantum meruit, which is essentially, hey, I did the damn work. Give me my money. It doesn't matter what. That's it. You owe me. It's fair. The district court, however, failed to mention, much less reckon with, Bowen or Knudsen before plowing ahead with its $2 billion order. Nor did it take account of any previous suggestion the proper remedy for an agency's recalcitrant failure to pay out may be to seek specific sums already calculated and past due. The most that can be said is that the district court's denial of the government's motion for stay pending appeal. It cited but did not analyze a handful of cases of the APA's conscribed waiver of immunity. One might expect more care. This is kind of brutal. Again, judges tend to be really light-handed with their comments about other judges. This isn't that way. one might expect more care from a federal court before it so blithely disregards sovereign dignity. Finally, the government has a strong argument. They're still saying that they have a good likelihood to have prevailed on this. This is an issue. We're not talking about it's a slam dunk of 9-0. The government has a strong argument that the district court's order violates the principle that a federal court may not issue a equitable remedy. My redneck is getting into me here. Remedy that is more burdensome to the defendant and necessary to redress plaintiff's injuries. Califano v. Where the hell do these people get these names? Yamasaki. Califano v. Yamasaki. That's back in 79. In this case, the district court's enforcement order functions as a universal injunction defying these foundational limits on equitable jurisdiction. In Alabama, it's more people kind of some states may treat them differently, but at least for in Alabama, a temporary restraining order was different than an enjoinment. When you're trying to enjoin someone, for instance, they've breached the contract, maybe they haven't made all the payments, and you file suit and you try to enjoin them from being able to execute something. You wouldn't do it under a TRO. That's a different statutory construction. This was from 2024 with Gorsuch being one of the ones. Obviously, they used it. I mean, he's the one voting with them. The district court ordered the government to pay all invoices, and no, guys, they do not like paragraphs in the Supreme Court. They're very weird about their margins, and everything just goes on forever. It's like an in perpetuity paragraph. District court ordered the government to pay all invoices and letter of credit drawn down. Of credit drawn down requests on all contracts. Again, I get the argument. It's like a quantum meruit type argument. You know, whether the contract was written or not, it was. Let's say you even had an oral one, and you say, "Hey, I'll pay you $5,000 to put a roof on my house." Okay, when does it begin? Well, I haven't paid him, but dude's on my roof putting the roof on. Takes him a day. He finishes the roof, and I say, "Nah, I'll give you $2,500." No, wait, I just freaking did your roof for $5,000, and we agreed on it. That's what you would file under. That would still be, for instance, the government. If that were, let's take that and let's connect it to the government and what we have now. If somebody has done something for, let's say, a contract. My dad worked for the Army Corps of Engineers, building stuff on U.S. Army installations. The contract's written. The government sometimes pays out in installments, and sometimes just after the job's over, and it's budgeted a certain amount of money. Congress says, okay, you can spend, I don't know, $12.5 million. That's it, and you better spend it. But if they do it and then say, "No, we're not paying it," that's the point of it's a quantum meruit. Hey, look, man, not only do I have a contract, I did it. I actually did it. So I need to get paid. So I get that argument. I mean, if these were like legitimate organizations and not NGOs and probably black ops hidden, or black ops buried inside of these NGOs to where they can get a high budget off book, I'd be more receptive. But I get the argument that, hey, look, man, we did this. We have a contract. You may not like it, but we need to get paid. Okay, fair. He goes on to say that order encompasses more than just respondents, and the district court offered no reason why universal relief to non-parties is appropriate here. This is not the sort of case in which only universal relief is feasible. Even supposing the APA allows universal vacatur of rules in some circumstances, the district court's order of direct monetary payment bears no resemblance to that. Kavanaugh respecting denial of application of stay. And nobody has suggested, It shouldn't be no one has suggested. Whatever. Why would you start the sentence with the word? Sorry, I'm nitpicking. I can't stand verbose stuff, and I have issues with the construction of a lot of the way people write. No one or nobody has suggested that the government is unable to identify respondents' allegedly owed funds and pay out only to them. Limiting the scope of relief in that manner would be significant. Below, the government represented respondents seek roughly 250 million, still a large figure. So it's not total 2 billion going out. Okay, it's not, or what was asked for, but a fraction of the 2 billion ordered. Emergency motion for immediate administration pending stay pending appeal. Now they go over to harm to parties and others. Let me change my color here. Boing. The government hath shown that it is likely to suffer irreparable harm if the district's court's order is not stayed. The government has represented it would probably be unable to recover much of the money it was paid because it would be quickly spent by the recipients or dispersed to third parties. Normally, even in contracts, they don't care. They'll say, okay, yeah, well, we'll just take you to court. That's fine. We'll deal with that, and they'll owe you, and you get a judgment on them. And it's like, well, hey, judge, that money's going to be spent. The judge is going to go, see you on the 30th or in 3 months, come back in 3 months at 2:00. That's just how the law works. It sucks. Respondents do not credibly dispute this representation. We usually balance the equities and weigh the relative harms in close cases. For the reasons I've explained, this is not the case, and our analysis could end there. Nevertheless, we're going to continue on with this fisting that we're trying to give our fellow court justices. Respondents' equitable arguments are insufficient to justify the denial of a stay. They contend that the failure to pay the money in question would cause them irreparable harm because without those funds, they could not continue to operate. I'm sympathetic. If they had a contract again, suffer. I don't care. It's at this point, freaking don't care. It's a scam agency. It's an executive order created agency. The president has the authority to go, done. We ain't doing it no more. Now, their argument is, hey, we're not trying to get money in the future. I mean, obviously, that's not going to happen. We're just trying to get paid for what we've done. But they don't know that that's happened. This may be stuff that hasn't even been done. Then it's just a breach of contract case. Can I sue the government? Can I sue the president for breaching contract or whatever? Not my problem as a citizen, but it is when it's our money being spent. These potential consequences are, of course, serious. Any harm. What in the hell? I've never seen any of this. That's kind of cool. It's like a freehand. Any harm resulting from the failure to pay amounts from the law requires it would have been diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeals. Meaning, you Court of Appeals, you suck. You suck. You suck. You suck. You should have done this. You should have done your damn job. Put the fries in the damn bag and give it to me. Okay? Just put the fries in the bag and give it to me. Should have promptly decided. They suck. I wonder if I can do this with a mouse. Suck. There we go. They suck. They're not doing their job. They're not doing their damn job. It says which it should not have dismissed. If we sent this case back to the Court of Appeals, it could still render a prompt decision. That it could. They probably could do it. Honestly, they could probably do it just as quickly as the Supreme Court did it. Why not? If they actually put down their bonbons and Fritos and quit dicking around and do a job, it would be great. We wouldn't have a case backlog either. If it decided in favor of respondents, the government would be obligated to pay all the money that is due, and respondents would have suffered only a short delay in the receipt of payments. If the government prevailed in its sovereign immunity argument, neither respondents nor any of the recipients of their services would have suffered any unlawful consequences. I mean, it's almost a way of, shut the hell up and go litigate the damn thing. You're not going to lose anything right now. In sum, the factors we consider for considering deciding whether to issue a stay weigh strongly in favor of granting that relief. And then they go on to again impugn honor of the court, or whatever you want to call it. Man, I don't see impugn the honor. Throw a friendly jab across the bench at their other justice, or the justices that found the opposite. The court makes an unfortunate misstep that rewards the act of judicial hubris and imposes a $2 billion penalty on American taxpayers. $2 billion. I cannot do this. Oh well. 2 billion. 2 billion. 2 billion with a B. That's a B. That's a really shitty B. It looks like Russell Greer's B. Oh shit! I probably shouldn't have said Russell Greer. He'll probably sue me next for making fun of his left foot signatures. $2 billion. 2 billion. Lots of money. Lots of money. Lots of ability to steal. And that's probably more likely than not. Like the AIDS foundations. Hey, where did that vaccine come? Oh, that's right. Oh no, never happened. No, that's odd. I had a friend die of it 25 years ago. He waited for it as long as he could, and that was it. So, wow, it's been a while. It's not ever going to happen. I'm sure that they're not trying to get a cure for it. Now they just take a bunch of pills and say, hey, go do what you want. Yeah. And go pass that around. Get some AIDS around. The district court has made plain its frustration with the government, and respondents raised serious concerns about non-payment for completed work. But the relief ordered is, quite simply, stupid. That's what it is. Stupid. Stupid. Extreme response. A federal court has many tools to address the party's supposed nonfeasance. Again, this case, the government, fact, can they really force the government to do a damn thing? I don't think so. I just don't think so. What are they going to do? Send cops down? Okay, the cops are not going to know how to take the money out of the bank. Well, there's no money and there's no bank. Regardless, they're not going to be able to know what the hell to do other than to hold up an order and go, I have an order of the Supreme Court or the district court. You got to let me do it. And they say, oh, well, I work for the president. No. He said no. What are you going to do? I guess then they start arresting everybody. Jails are going to fill up really freaking quick. There's nothing they can do. It's nothing they can do. This only works by us acquiescing rights and authority and saying, okay, well, I don't agree with it, but yeah, all right, I got to do what the court said. If it's just one of us, I'll just come kick your door in and throw your ass in jail. If it's the president who has an army at disposal, and not necessarily the army because they can't be used in police functions under posse comitatus, which I wonder if my Confederate ancestors would not have gone back and said, well, maybe we shouldn't get rid of that for Reconstruction to end. Maybe we should allow that. That's another. Anyway, I'm going to quit going off on a rant here. But I thought I'd go over this. It's an interesting view that Alito, at least, and the other three had against what the president should be able to do. Or at least litigate it. Stop and at least litigate it. Let's don't be stupid. He says, I would chart a different path than the court does today, so I must respectfully dissent. I probably would have been a little bit more of a dick about it. This is not a long order. Many of these would have ended, with a per curiam decision right here, page 1. That's it. And sometimes not even that much description is given. So that is where we're at with the TRO on the AIDS case. No pun intended AIDS Foundation. Yeah. Okay. I do. Yeah. That is actually kind of funny. So the AIDS case, and whether or not that $2 billion is going to get paid out, I don't know what Trump's going to do. He could tell the Treasury, no. Again, what's the Supreme Court going to do? What's the district court going to do? There's nothing. I don't think they can do anything. I think he should craft a little letter, nice little letterhead with his little magic, his famous marker, and say, well, Mr. Chief Justice, you have your order. Good luck enforcing it. Signed, Donald J. Trump, President of the United States. That's what I would do. All right, guys, remember, like and subscribe, please. And remember, it's a club. That's why you have issues. It's a club, and you're not freaking in it. Thank you, George Carlin. Thanks, y'all. See you later. Thanks, John.